Article 1. This act shall be known as the Civil Code of the Philippines. Article 2. Laws shall take effect after 15 days following the completion of their publication, either in the Official Gazette or in a newspaper of general circulation in the Philippines, unless it is otherwise provided, as amended by EO 200. Article 3. Ignorance of the law excuses no one from compliance therewith. Article 4. Laws shall have no retroactive effect unless the contrary is provided. Article 5. Acts executed against the provisions of mandatory or prohibitory laws shall be void, except when the law itself authorizes their validity. Article 6. Rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Article 7. Laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse, or custom or practice to the contrary. When the courts declare a law to be inconsistent with the Constitution, the former shall be void, and the latter shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. Article 8. Judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. Article 9. No judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Article 10. In case of doubt in the interpretation or application of laws, it is presumed that the law-making body intended right and justice to prevail. Article 11. Customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12. A custom must be proved as a fact, according to the rules of evidence. Article 13. When the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated for their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded and the last day included. Article 14. Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Article 15. Laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Article 16. Real property as well as personal property is subject to the law of the country where it is situated. However, intestate and testamentary succession, both with respect to the order of succession and to the amount of successional rights, and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs, shall not be rendered ineffective by laws or judgment promulgated, or by determinations or conventions agreed upon in a foreign country. Article 18. In matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. Chapter 2. Human Relations. Article 19. Every person must, in the exercise of his right and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 20. Every person who, contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. Article 21. Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy, shall compensate the latter for the damage. Article 22. Every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of the latter, without just or legal ground, shall return the same to him. Article 23. Even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Article 24. In all contractual, property, or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. Article 25. Thoughtless extravagance in expenses for pleasure, or display during a period of acute public want or emergency, may be stopped by order of the courts at the instance of any government or private charitable institution. Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief: prying into the privacy of another's residence; 2. Meddling with or disturbing the private life or family relations of another; 3. Intriguing to cause another to be alienated from his friends; 4. Vexing or humiliating another on account of his religious belief, lowly station in life, place of birth, physical defect, or other personal condition. Article 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter, without prejudice to any disciplinary administrative action that may be taken. Article 28. Unfair competition in agricultural, commercial, or industrial enterprises, or in labor, through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damage. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case the judgment of acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not the acquittal is due to that ground. Article 30. When a separate civil action is brought to demand civil liability arising from a criminal offense, and no criminal proceedings are instituted during the pendency of the civil case, A preponderance of evidence shall likewise be sufficient to prove the act complained of. Article 31. When the civil action is based on an obligation arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings, and regardless of the result of the latter. Article 32. Any public officer or employee, or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages: freedom of religion; 2. Freedom of speech; 3. Freedom to write for the press or to maintain as periodical publication; 4. Freedom from arbitrary or illegal detention; 5. Freedom of suffrage; 6. The right against deprivation of property without due process of law; 7. The right to a just compensation when private property is taken for public use; 8. The right to the equal protection of the laws; 9. The right to be secured in one's person, house, papers, and effects against unreasonable searches and seizures; 10. The liberty of abode and of changing the same; 11. The privacy of communication and correspondence; 12. The right to become a member of associations or societies for purposes not contrary to law; 13. The right to take part in a peaceable assembly to petition the government for redress of grievances; 14. The right to be free from involuntary servitude in any form; 15. The right of the accused against excessive bail; 16. The right of the accused to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witness in his behalf. 17. Freedom from being compelled to be a witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing becomes a state witness. 18. Freedom from excessive fines or cruel and unusual punishment, unless the same is imposed or inflicted in accordance with a statute which has not been judicially declared unconstitutional. And 19. Freedom of access to the courts. In any of the cases referred to in this article, whether or not the defendant's act or omission constitute a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution, if the latter be instituted, and may be proved by a preponderance of evidence. The indemnity shall include moral damages. Exemplary damages may also be adjudicated. The responsibility herein set forth is not demandable from a judge unless his act or omission constitute a violation of the penal code or other penal statute. Article 33. In cases of defamation, fraud, and physical injuries, a civil action for damages, entirely separate and distinct from the criminal action, may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Article 34. When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefor. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Article 35. When a person claiming to be injured by a criminal offense charges another with the same for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Article 36. Prejudicial questions which must be decided before any criminal prosecution may be instituted or may proceed shall be governed by the rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. Article 3. Ignorance of the law. Reviewer reference Aquino, 2018. Ignorance of the law excuses no one from compliance therewith. This provides for a conclusive presumption. This rule applies only to mandatory and prohibitory laws. However, it also applies to Supreme Court decisions. B. Mistaken, doubtful, or difficult interpretation of law may be the basis for claiming good faith. Mistake of law must be distinguished from mistake of fact. Mistake or ignorance of fact may be the basis for claiming absence of intent. It may also vitiate consent in contracts. Article 4. Non-retroactivity of laws. Exceptions. When the contrary is expressly provided by law. 2. Interpretative statutes. 3. Procedural, remedial laws. 4. Curative statutes. Statutes that were enacted to cure defects, abridge superfluities, and curb certain evils. 5. Laws creating new rights. 6. Emergency laws. And 7. Tax laws. Even if the law provides for retroactivity, the same is invalid if it is either 1. An ex post facto law, or 2. A law that impaired the obligation of contracts. If the law takes away rights or creates rights, example creating a right to appeal, then the law is not procedural. It is procedural if it merely operates as a means of implementing an existing right. Article 5. Mandatory or prohibitory laws. Exceptions. When the law itself authorizes the validity of the act. When the law makes the act only voidable and not void. Or when the law makes the act valid but punishes the violator. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs, shall not be rendered ineffective by laws or judgment promulgated, or by determinations or conventions agreed upon in a foreign country. However, the Civil Code in certain cases sanctions the application of foreign laws, even in proceedings in the Philippines. Examples: Article 15 of Family Rights, Duties of a Foreigner; Article 16 with respect to order of succession, successional rights, intrinsic validity of a will or a foreigner; and Article 1039 on the capacity to succeed of a foreigner; and Article 1753 in international carriage of goods where the destination is another country. Article 15. Family rights and duties of the status, condition, and legal capacity of persons involved, Filipino citizens. Applicable laws. Philippine laws apply even if the citizen is abroad. This is called the rule of lex nationali. Family rights and duties or the status, condition, and legal capacity of persons, example, capacity to contract marriage. Persons involved, foreign national. Applicable law, lex nationali. The laws of the country of the foreign national apply. Article 15 of the new Civil Code. Crime, public security, and safety within Philippine territory. Persons involved, Filipino citizens, those who live and sojourn in the Philippines. Applicable laws, Philippine laws, but subject to the principles of international law and treaties. Article 14. Properties, both real and personal, persons involved, Filipino or foreign national. Applicable laws, Lex Rey Cite, Philippine laws for properties in the Philippines, Article 16. Intestate and testamentary succession with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provision. Person involved, Filipinos. Philippine laws applicable, Article 16. Intestate and testamentary succession with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provision. Persons involved, foreign national. Applicable laws, law of the country of the foreign national, Article 16. Formalities, forms and solemnities of contracts, wills and other public instruments. Persons involved, Filipino or foreign national. Applicable law, Lex Loci Celebrationis, law of the country where executed, Article 17. Example, if the contract was executed in the Philippines, Philippine laws apply with respect to formalities. This includes those executed in the Philippine consulate or embassy abroad. Article 6. Waiver of rights. The general rule is that rights can be waived. The following are required for the waiver. 1. Existence of a right. 2. Knowledge of the existence of a right. 3. Intention to relinquish the right. Exceptions: when rights cannot be waived if the waiver is contrary to law, public order, public policy, morals or good customs, or 2. If the waiver is prejudicial to a third party with a right recognized by law. Vested right. It is one whose existence, effectivity, and extent do not depend upon events foreign to the will of the holder, or to the exercise of which no obstacle exists, and which is immediate and perfect in itself and not dependent upon a contingency. The term vested right expresses the concept of present, fixed interest, which, in right reason and natural justice, should be protected against arbitrary state action, or an innately just and imperative right, which enlightened free society, sensitive to inherent and irrefragable individual rights, cannot deny. To be vested, a right must have become a title, legal or equitable, to the present or future enjoyment of property. Deprivation means that while one may not be deprived of his vested right, he may lose the same if there is due process and such deprivation is founded in law and jurisprudence. Example, whenever forfeiture under Articles 129 and 176 of the Family Code apply. Human Relations, Article 19. When a right is exercised in a manner that does not conform with the norms enshrined in Article 19 and results in damage to another, a legal wrong is thereby committed for which the wrongdoer must be held responsible. However, Article 19 is the general rule which governs the conduct of human relations. By itself, it is not the basis of an actionable tort. Article 19 describes the degree of care required so that an actionable tort may arise when it is alleged together with Article 20 or Article 21. Article 20 provides that every person who contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. On the other hand, Article 21 provides that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy, shall compensate the latter for damages. Articles 19, 20, and 21 provide the legal bedrock for the award of damages to a party who suffers damage whenever one commits an act in violation of some legal provision, or an act which, though not constituting a transgression of positive law, nevertheless violates certain rudimentary rights of the party aggrieved. These are so-called catch-all provisions because they provide the basis for actions for damages in the absence of any express provision. Abuse of rights violates the norms enshrined in Article 19. The requisites of abuse of rights are as follows. There is a legal right or duty. The legal right or duty is exercised in bad faith, and the exercise is for the sole intent of prejudicing or injuring another. Examples of cases where there is abuse of rights: a creditor taking advantage of his knowledge that insolvency proceedings were to be instituted by the debtor if the creditors did not come to an understanding as to the manner of distribution of the insolvent's asset among them, and believing it most probable that they would not arrive at such understanding, schemed and transferred its credit to a sister company in the United States, which in turn secured a writ of attachment in the court therein, thereby gaining control over the claim of the debtor. The mortgagee abused its right when it recovered the mortgage vehicle without court action preliminary to the enforcement of its right to foreclose on the mortgage in case of default. There is abuse of right if the principal unreasonably terminated an agency agreement for selfish reasons. There was abuse of right when complainant was prevented from performing her duties as Deputy Commissioner of the Bureau of Customs, despite the preliminary injunction issued by the court against the replacement of the complainant. There was abuse of right where a temporary restraining order was issued by the Court of Appeals against the writ of demolition issued by the lower court, but the petitioners still pursued the demolition. There was abuse of right in this case, and the fact that the writ of demolition was not subsequently annulled is of no moment. There was also abuse of right when the petitioner unduly terminated its hauling contract with private respondent Cruz, whereby the latter supplied trucks for the hauling of the products of the petitioner, because the latter sympathized with the picketing workers of the petitioner. There was abuse of right when a lady was falsely accused of not paying items of clothing, despite the issuance of receipt and release of the purchased items. The defendant went overboard by forcing her to pay, and in the guise of asking for assistance sent a letter to the employer imputing bad faith. Under acts contra bonus mores, the defendant may be held liable for damages caused when his or her action is contrary to Article 21 if the following requirements are present. There is an act which is legal. Number 2, the act is contrary to morals, good custom, public order, or public policy. And 3, the act is done with intent to injure. Breach of promise to marry by itself is not actionable. By way of exception, breach of promise to marry may be actionable for being contrary to morals, good customs, public order, or public policy. Thus, breach of promise to marry is actionable in the following cases. 1. When there is moral seduction, or when the woman was seduced through trickery or some ingenious scheme. Example, the frequent visits were allegedly to teach the woman to pray the rosary. When the wedding was cancelled after formally setting the date of the wedding and after all the preparations, gowns, invitations, reception, and so on, and after spending substantial amounts. When the man failed to appear during the ceremony with the intent to humiliate or embarrass the woman. And in some cases, money advanced to one party may be recoverable based on quasi-contract. Malicious prosecution may be both considered abuse of right and an act contra bonus mores. The elements of liability are: 1. The fact of the prosecution, and the further fact that the defendant was himself the prosecutor, and that the action was finally terminated with an acquittal. That in bringing the action, the prosecutor acted without probable cause. And finally, the prosecutor was actuated or impelled by legal malice. There is inexcusable intent to injure, oppress, vex, annoy, or humiliate. Probable cause is defined as the existence of such facts and circumstances as would excite the belief in a reasonable mind that a person charged and prosecuted in a criminal case is probably guilty of the crime or wrongdoing. The elements must also be present if there is allegation of malicious prosecution of civil case, otherwise the case is damnum absci injuria. Article 22. Unjust enrichment. Conditions. The two conditions that are required for the principle of unjust enrichment to apply under Article 22 are as follows: that a person is benefited without a valid basis, or justification, and 2, that such benefit is derived at another's expense or damage. Action in rem versa. One may be made liable in this type of action that is justified under Article 22 if the following requisites are present. 1. The defendant was enriched. 2. The plaintiff has suffered a loss. 3. The enrichment of the defendant is without just or legal ground. And 4. The plaintiff has no other action based on contract, quasi-contract, crime, or quasi-delict. Types of violation of the rights to privacy under Article 26. Intrusion upon the plaintiff's seclusion or solitude or into his private affairs. 2. Public disclosure of embarrassing private facts about the plaintiff. 3. Publicity which places the plaintiff in a false light in the public eye. And 4th, appropriation for the defendant's advantage of plaintiff's likeness or name. The phrase prying into the privacy of another's residence under Article 26, number 1 of the Civil Code covers places, locations, or even situations which an individual considers as private. And as long as his right is recognized by society, other individuals may not infringe on this right or to privacy, as a person has a reasonable expectation of privacy in one's property, whether he or she uses it as a business office or as a residence, and that the installation of video surveillance cameras directly facing one's property or covering a significant portion thereof without his or her consent is a clear violation of their right to privacy, and this is a form of intrusion. One has reasonable expectation of privacy in one's property whether the property is being used as a business office or residence. There is also violation of the right of privacy because of intrusion in a residence and in ordering an employee to take pictures of the residence. Fictionalized account of life. The Supreme Court ruled in one case that the right to invade a person's privacy to disseminate public information does not extend to fictional or novelized representation of a person, no matter how public a figure he or she may be. Online social network. The Supreme Court explained in Vivaris v. St. Teresa's College that before one can have an expectation of privacy in his or her online social network activity like Facebook, Twitter, Instagram, it is first necessary that said user manifests the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. And this intention can materialize in cyberspace through the utilization of the online social networks privacy tools. In other words, utilization of these privacy tools is the manifestation in cyber world of the user's invocation of his or her right to informational privacy. Thus, there is no reasonable expectation of privacy if the Facebook setting is public, or even if the setting is friends only. In the latter, posts can still be viewed even by non-friends. In alienation of affection, one may be liable for alienation of affection of spouse if the following are present. There must be a valid marriage. 2. Wrongful conduct with the plaintiff's spouse. 3. The loss of affection or consortium. And 4. Proof of causal relation between the conduct of the defendant and the loss of affection or consortium. Article 29. Dependent and independent civil action. Dependent civil actions are actions to enforce civil liability arising from criminal liability. Civil liability arising from crime or delict is impliedly instituted with the criminal action, but a separate case may be filed to enforce the same. Such case may be filed ahead of the criminal action and after reservation, upon rendition of final judgment in the case. However, in both cases, the civil action is dependent on the criminal action. This is manifested by the following rules with respect to dependent civil actions. 1. If the case was filed against of the criminal case, the separate action shall be suspended until a final judgment is rendered in the criminal case. 2. If no case is filed a separate case cannot be filed until rendition of final judgment. And 3. Civil liability is extinguished if the criminal case resulted in an acquittal with a finding that the act complained of was not actually committed by the accused. And the effect of acquittal, Section 2b of Rule 111 of the Rules of Criminal Procedure states that civil liability is extinguished if the criminal case resulted in acquittal with a finding that the act complained of was not actually committed. When the civil action is based on an obligation not arising from the act or omission complained of, as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. These so-called independent civil actions include 1. Action based on quasi-delict. 2. Action for violation of civil and political rights under Article 32. 3. Action for defamation, fraud, or physical injuries under Article 33. And 4th, action for neglect of duty by public official under Article 34. The rationale of Article 32. The application of Article 32 not only serves as a measure of pecuniary recovery to mitigate the injury to constitutional rights, it likewise serves notice to the public, officers, and employees that any violation on their part of any person's guarantee rights will meet with final reckoning. Public officials and employees, as well as private individuals, may be held liable. Even those who indirectly violate the constitutional rights can be made liable. Example, a prosecutor can be made liable if he issues an order of seizure, although he is not authorized to do so under the Constitution. Private individuals can be made liable for disconnection of electricity connection without due process of law. A private corporation that was made liable because it caused the raid on the premises of the respondents, which violated their rights against unreasonable searches and seizure. For civil liability for fraud to be awarded, the defendant must have made a false representation of fact to the plaintiff, and the defendant knows that the representation is false. The plaintiff must have acted on the false representation, and the defendant must have intended that representation be acted on. Under physical injury, independent civil action for physical injuries include an independent civil action for bodily injuries resulting in death. No reservation requirement. The independent civil action shall proceed independently of the criminal case. There is no need to reserve the right to file an independent civil action under Articles 31, 32, 33, and 34. Under the new Civil Code, a single act or omission may give rise to two separate causes of action. The separate causes of action may be based on quasi-delict under Article 2176 or on any of Articles 32, 33, or 34 of the new Civil Code. In fact, the separate basis of liability may even be contract. The rule is expressly recognized under Article 2177 in Articles 32, 33, and 34, subject only to the proscription against double recovery. Article 2177 of the new Civil Code provides that the plaintiff cannot recover damages twice for the same act or omission of the defendant. In other words, although there are concurrent bases of liability, the plaintiff can only recover once. Article 36, Prejudicial Question. The general rule is that the criminal case takes precedence over civil actions. The exception is provided for under Article 36 of the new Civil Code, that provides for prejudicial questions which must be decided before any criminal prosecution may be instituted or may proceed. Requisites of prejudicial questions. The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and the resolution of such issue determines whether or not the criminal action may proceed.